But she talked with George, and George had talked to you, and George had talked to Grover, and George had talked to Jean. So that's 3. 1, 2, 3.
Yes, ma'am, but she also indicated to me before the meeting and before the phone call from George that she had pretty much marching directions from 3 commissioners that it was time for him to go. No, ma'am, I was not one of them, and she specifically excluded me in that conversation. She said I was not part of it. So, like I said, it doesn't matter now. Well, apparently it doesn't, because 2 people can't say 2 different things and both of them be completely accurate. There's an inaccuracy somewhere, and I don't care.
I have not said anything inaccurate.
Kevin, I agree. You ponied up and you said you were ready for him to retire.
Yeah, and understand that it was very important from George's perspective that he not be terminated. He did not want to be terminated without cause. He was very distressed about that. He was looking for the ability to terminate the agreement voluntarily rather than have on his record
which there was a provision in his contract for that.
Right.
Because you went over both those options with me when I came to you and asked him for you to go ask him to resign.
So it was what we thought we were doing was, preserving his ability to be marketable somewhere else as a county administrator, not have a firing on his record. That was the intention behind the resignation as opposed to termination.
Nancy, just we move on.
Yeah. I think we will.
But just one question. According to Mike, we haven't resolved this. Do we need to terminate him without cause?
In my opinion, he has exercised his right under the agreement to unilaterally terminate that agreement. And until he comes forward and he says that he disagrees, he thinks that the board did something in contravention of the contract and seeks judicial resolution on that, I don't believe that you have to do anything more. Currently, Mr. Stewart is receiving benefits pursuant to the terms of the contract. He will continue to do so until December 31st, at which time he will receive a lump sum payout of all of the benefits that he has accumulated as a result of his employment.
And that's one that will be settled in court, because I don't see how you can read resignation into the word retirement. He announced his intention to retire. He indicated that there were some trust issues, but I believe that was predicated on his assumption, and I believe your assertion to him that there were 3 commissioners supportive of not of the agreement, but of his leaving. And, let the court decide it. That's fine. It's just unfortunate because the appropriate process for terminating a county administrator is codified. It gives everybody fair notice. It's an open public process. And if we had wanted to simply do an at-will dismissal without cause, that motion could have been made. But that's never been done either. What we've done has been the worst of all scenarios. We've not followed any of the rules, and we're just letting it hang and hoping that it doesn't end up in a civil courtroom somewhere. That's unfortunate.
But recall that the contract does not speak in terms of resignation or retirement in that provision that allows George to unilaterally terminate the agreement. He simply has to give notice to the board that 90 days advance notice that he's not going to be county administrator anymore, and he doesn't have to give any reason.
Isn't that what he did?
Yes.
What he basically said was, I'm going to announce my retirement because I don't believe I can do the job the way you want it done, so I'm not going to renegotiate my contract. That's the essence of his statement.
But Mike, if he wanted to get all the way to April and be on administrative leave until April, it would have required an amendment to that contract. And I was working on that with him, and until the board approved it, he had no entitlement to rely on any of that.
If you pull the minutes from the meeting, you'll see that his request was that he be placed on administrative leave until an appropriate settlement could be obtained. Right. An appropriate settlement, if it were within the terms of the contract, would have then been he would have gone back to work because there was a gap.
I understand that's how you feel.
Well, it's not a question of how I feel. It's just simply what the statement reads. He announced an intention to retire in April of 2008. Nothing more. He didn't say,
Well,
I'm
actually,
quitting
there
and I
was
want to go
more.
out on leave until then. He said, I want to be on leave until we negotiate a settlement.
Well, he also said that it was
he could not
impossible
serve
for
in
him,
that capacity.
right, to continue as county administrator. But, all right, that's all water under the bridge. The bottom line is, it doesn't matter what I or any of your staff are negotiating. Nothing is binding upon anyone until this board meets and approves whatever package we are negotiating on your behalf. George should have known that, and he got ahead of himself and announced his intent before the severance package had been negotiated. I would have brought that package to you and presented it to you in normal fashion for you to vote on, and then he could have decided as to what announcement he wanted to make.
Janet, plain and simple, do you really believe he'd have made that statement if he hadn't have believed there were 3 commissioners ready for him to go?
I think it was wishful thinking on his part that because he knew,
didn't answer my
Mike,
question.
he knew that we had no meeting of the minds on the agreement.
Do you believe that he felt like there were 3 commissioners that were supportive of his leaving?
I can't say what he believed.
Did you communicate that to him, that there were 3? Because I believe you did.
That there was support for his severance package, yes.
Thank you. Well, so he had an inducement. He had every reason.
That's not reasonable. He's the county administrator. If he doesn't know that an agreement isn't final until the board approves it, then nobody in this county knows it.
Okay. My point is simply, he was led to believe that there was support to move forward. And I'm not going to argue, did he jump the gun? Clearly he did. But he jumped it because he felt like the support was there to move forward. That's all. I mean, you said it.
Just
That's
because
He jumped the gun because he thought he was going to get fired that night.
Which is, he felt like the 3 votes were there. You know, that's.
But it would have taken 4 votes to fire him.
That's exactly right. So I think he was under the impression the votes were there to support the retirement package, not a firing, because he knew there wasn't 4 votes to fire.
But we were changing the ordinance that night, that same night.
No, well, but we hadn't. The point is, it couldn't have happened that way. So, yeah,
It couldn't after we changed the ordinance, turned right around and fired him on the 3-2?
I don't think so, because in order to fire him, you've got to follow the county administrator ordinance, and there's a process for that.
Well, that's the ordinance we were changing.
Which I
No, the process requires notice and his appearing at a board meeting to follow. I mean, we've been through that before in this
Well, he
meeting.
has. Yeah,
There is a process
there
that
is
we
a
would have had
process.
to follow.
It would have been very rapid and easy to comply with.
Absolutely, but we didn't.
Yes.
My point is, we didn't play by the rules.
We did. The board did. You know.
I don't want to argue with an attorney. I can't win. But, you know, all I've said is I believe
You believe he should have been
was led to
terminated.
believe that there was support for his package. And that's the reason he
Yes,
did
there
it.
was support.
Okay,
But the
thank you.
county
Support
administrator
for what package?
to work up a severance package.
Yes.
You know, you don't just resign without a severance package.
But he had that in his contract.
No, sir, that is not correct. What he had was a provision for termination at will and provision for termination of his own volition. This was a beast of a different nature.
But why was I turned down? I was trying to bring something forward. And I got shot. I couldn't get a motion on one, and it failed 4-0 on the other. I mean, my motion...
Your issue was never discussed. Option 4 never came for discussion whatsoever. Never was. No.
I think what he's talking about is the first special meeting, he made a motion for option 2 and nobody seconded it. That's before Grover and he and Marie
That was true. In the meeting prior, I was trying to help him get to retirement with dignity based on him being able to buy in to his retirement date. He would have to switch out of his 401k or his investment plan and roll those dollars into an FRS program. The FRS program requires 6 years of work. He had approximately 5.5 years when he announced that night. So there had to be a mechanism in place to get him to April 2nd. That's all I was suggesting is that we research how we might be able to do that. And I made a motion to allow the county administrator to look into that. And I was turned down.
I don't recall.
I was
It was-
turned down
it was
before,
a-
in fact, I did not have a second on it.
That was what it was. It was not you were turned down.
Well, I was turned down. I didn't get a second on it.
Well, at that particular time, I believe there were only 3 votes in the chamber at that point, and I felt this is something, I wasn't a second, because I felt this is something important enough that all 5.
I can't control the attendance of